Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy, powered by TrustArc. Here are your hosts, Dr. Kay Royal and Paul Breitbart.
So, oftentimes on Serious Privacy, we're bringing you the hottest and breaking news. And sometimes we break down and we talk about some of the fundamentals of a privacy program or foundational questions you need to address. Today is going to be one of those fundamental aspects of a privacy program that none of us actually like to do. With that, I'm Kay Royal.
And I'm Paul Breitbart, and welcome to Serious Privacy. And yes, you realize that we are shaking things up a little bit this week with Kay doing the intro. And that means that I am doing the icebreaker question, which I'm currently looking at some options to see. And let me see. I do like this one. What is the defining movie for your generation?
Ooh, defining movie I can answer. Defining movie for my generation.
Mm-hmm. Well, for when you grew up.
Yeah, it's going to be Star Wars.
Which one of the 27 million versions?
It started in my generation. The very first Star Wars movie came out when I think I was like 7 or 8, something right around there. So,
and if I remember correctly, that would be number 4, right? The very first one, to make sense of all of it.
Exactly. The first one was number 4.
Okay.
What about you?
Well, looking at my high school time, or what Americans would call high school, it probably would be Titanic.
Oh, yeah.
That's probably the film that literally everybody in my school had seen, where you would go on dates, and probably Titanic.
You know, when you first mentioned of my generation, I was thinking college, because the big movie in college in the 80s, late 80s, Mississippi Baptist College. It was Mississippi College, which is a Baptist college. Nobody imagines I went to a small Baptist college for undergrad.
But you did.
There you go. Was Dirty Dancing.
Oh, yeah,
because
of course.
We were Baptists.
Nobody puts baby in a corner.
But everybody said I looked like Jennifer Grey in Dirty Dancing. Both the attitude and the looks and everything. And I just thought it was hilarious. So anyway.
I can certainly imagine the attitude.
Right? Nobody puts baby in the corner.
Exactly. And nobody puts gay in a corner.
Right. Exactly. Or at least I'm not going to stay there if you do. But it does remind me that when I went to the LGBTQ party dressed as the Queen of Hearts, I was still me. So for the first 20 minutes or so, I still sat in a chair against the wall, just kind of people watching.
Being a wallflower.
Now, it didn't mean like at an airport people watching, because people were right there packed knee to knee. But 2 people came over and adopted me into their efforts, Sarah and Grace. They were phenomenal. They got me out of my chair and into the party, which is where I found Megan. So that was really good. And I will be forever indebted to Sarah and Grace. Apparently, Grace is the one that made a lot of the cookies and stuff for the party. I'm hoping it was Grace. It might have been Sarah, but does a phenomenal job baking anyway. But phenomenal people. Absolutely. So that brings us into today's fundamental aspect of privacy programs, which nobody wants to talk about.
Now, I thought you were going to say something fun, but then it became fundamental. And this
Right.
topic is
But
not fun.
no fun. Take the fun out of demental. It is kind of demental too, so we'll leave it
It
at that
is.
one. This is the demental episode, no fun. Oh gosh, we're going to play on that one, aren't we? But with this, I want to give a disclaimer, and I think we've said this in other episodes, but just so people know, when Paul and I are talking about experiences that we've had over data protection and privacy, they span back all the years that we've been doing this. So it doesn't necessarily mean just because we mention an issue in privacy someone might address that either one of us is dealing with it at our current employers. Paul's been a regulator. He's been a consultant. I've been a consultant and employee. I've been in privacy a long time. It could very well be things we've heard of from our colleagues and our acquaintances and our friends that complain and moan and vent and everything. So just know that nothing we say could necessarily be attributed to our current employers. And in fact, we typically go out of our way to make sure that any of the examples we give do not belong to our current employers. So let's keep that in mind as we do. With that, what do y'all think the demental thing we're going to talk about? Data inventory and data mapping.
Woohoo. Look at my excited face.
Right. I think this is one that we really should start doing video on because both of us are on cell phones because neither one of us are in our normal environments right now. Mine is simply because they've cut the power off to the house and the internet. So, working on the foundation. And so I can't look up anything online. I'm taking all of my power to do my data here. So we're just going to have to go from experience. But Paul, tell me about when your experience first started in data protection, your approach to data inventory and data mapping and why we need to do this. Nobody likes it. Let's be honest.
Well, when I started in data protection, that basically was with the Data Protection Authority. And there was no legal obligation for the old data protection because we are now talking, 2009, 2010. There was no obligation to do a full data inventory, a full data mapping. At the same time, during investigations, of course, we would ask data controllers and data processors, hey, tell us about what data are you processing? How are you doing it? What information do you capture about individuals and how are you storing that? And where is the data coming from? All of that we would do. What is your legal basis? I think there was an assumption that somehow organizations were documenting what kind of data they were processing for which reason and how long they would keep it. Because even though it was not a literal legal obligation to keep a register such as we now have in Article 30 of the GDPR, it was something that was implied by the legislation probably. But I don't believe that anybody at that time would have a full inventory the way that we would have it today, fully driven by software or even in some situations by spreadsheets.
Right. But there was the understanding that in order to provide the information being requested, you had to know that information. And if you knew the information, why wouldn't you document it somewhere? Because who's going to remember all of this? But that was the same here in the US. Of course, my first foray was HIPAA. There is no requirement under HIPAA to have a data inventory or a data mapping, but it did have individual rights where they could ask what data you had on them and things like that. But again, not a record of processing activity. You had to tell them who you shared their data with. The logging part of who accessed their data for treatment, payment, and operations you didn't necessarily have to give. But you had to be able to tell them what you did with their data. And so it's interesting that these assumptions have now kind of, and I'm not going to say they have kind of solidified to a part of the program that every privacy program has are records of processing activities, the ROPAs, the Article 30 reports, whatever you want to call them under GDPR, because otherwise, how do you produce the transparency and the notices that the different laws require. How do you give individuals the information of where their data is shared if you're not documenting this and tracking this where it is? But that doesn't mean that it makes it any easier for companies to do. I mean, it can be very complex.
Are you basically saying that, hey, despite the fact that we do not like it, it actually does make sense to have a data inventory?
It does make sense. It really does. And again, like one of the things that frustrates me is that a processor is only required to produce certain pieces of information for a record of processing activity. Processors don't determine the legal basis of collecting or processing the data. Controllers determine the legal basis. However, we all know that that whole designation of controller and processor really doesn't make sense in the reality that we live in. But it does make it frustrating when you tell controllers what you're doing and controllers come back and say, well, what's your legal basis of processing? We're like, we're the controller. We're the processor. You're the controller. You need to tell us what the legal basis of process is, because technically we're processing this on your orders, which we all know doesn't really happen. You're the one that's supposed to determine the legal basis of processing. Now, what you can do is either verify that legal basis of processing with your controllers or document what you think the legal basis of process is, and then make sure that your controllers validate that that's the legal basis of processing.
So there you assume that the legal basis is part of your data inventory, which if you follow the GDPR very strictly is not the case, because Article 30 does not include the legal basis. I would always include it because I don't see why you wouldn't document it if you are documenting all the other stuff already. And I really do believe this is an oversight from the legislator. I've said it before also on the podcast that this should be updated in one of the next versions of the GDPR. But strictly speaking, legal basis is not there. It does make sense.
It does make sense.
And indeed, it is up to the data controller.
But here's the thing. What it does require is that you document the data you collect, the categories of data subjects, the categories of data elements. You have to document what categories of third parties you're sharing the data to. You have to actually capture who you're sharing it to, but on the record of processing, it's the categories of data processors. You have to capture if you're transferring the data to third countries or an international company, which, by the way, reminder, an international
organization.
Thank you. Does not mean a company that does business internationally. It means a very specific definition under GDPR that means essentially entities that have their own processing rules for
their own legal statute, like the United Nations,
Red Cross, United Nations.
Exactly.
Yeah. Things like this. There's about 130 of them, I think, officially recognized.
Something like that.
TrustArc has them listed in their things that you can gather, but there's lists out there of who the international organizations are. So you have to list those. You don't actually have to capture your process from the legal perspective of data enters us at this. We use these systems to do it. These systems go to these things, go to those systems, go to that system, talks to this. You don't actually have to track a data flow or a data process like you would an architectural drawing process, but it's actually a good thing to know.
Well, it's really useful if you want to explain to somebody, hey, this is how we process your personal data that you should do in your notice. Then it helps for yourself, at least it helps me. Let's not generalize, but it helps me to visualize the process. I know not everybody is able to look at those diagrams and say, okay, I can make sense of it. Others prefer to just do the storytelling. But for me, that really helps to visualize and then explain all the various steps, because then you can also see, oh, wait, there is a part going away here. I need to also describe that because I haven't covered that yet. So a few questions for you, Kay. Are you in favor of an activity-based register or a software-based register? Tools-based register?
I like the activity-based because I look at it from the business perspective. However, I like the software-based too because it looks at it from the systems and the application level. So I typically do both. It used to be in GDPR when we're working as consultants and we would help companies. There were data discovery companies that said, we can tell you what systems you're using, blah, blah, blah. people would say, oh, well, we need that. And others would say, well, no, we need to interview the business people. You need both. You need to understand your discovery system can tell you, what applications you have social security numbers in, or at least numbers that meet the definition of a national identifier or social security number. It's not going to give you the context as to why you have that. And it's not going to tell you which system is your source of truth. So that part you have to get from the business interviews and talking to the business, which makes it, you need both. You need both.
Well, for the quick and dirty, for the easy setup, and for not hindering your primary process too much, I think the software-based is very suitable approach.
Yes, absolutely suitable.
It already gives you a lot of the information that you want to have. It gives you a lot of insights. And it also has the advantage that you can have one person who also keeps track of all the software also help to ensure that the register stays up to date.
Yep. Coordinate those activities there.
The activity base is much more difficult to set up because indeed you need to interview the business, and trying to find time with the business for these kind of interviews is always the lowest priority.
Well, and try to make sure that they give you what you need.
Well, you first need to explain to them, hey, this is what I'm going to need. Then they need to think about it. And then you need to also be able to ask the pointed questions to get all that information. I don't believe in data discovery, to be honest. I'm sorry for all the data discovery companies out there. I've tested a few. Results were mediocre at best. And maybe that has improved in the past 2 to 3 years. But what I've seen before, I wasn't too excited. Plus, don't like the fact that there is another tool crawling through my network trying to figure out what all is there. And that might just be me, but okay. Okay, so ideally, yes, activity-based, but software-based is a good alternative. Then the other point, are you in favor of a centralized system or a decentralized system? So centralized as in run by the legal team or privacy office, and decentralized with the business being responsible to update their own processes.
I like a hybrid. I like the knowledge and the tools coming through.
You really are a lawyer, right? It depends.
I really am a lawyer.
On both sides.
But I do. I like the privacy, because the privacy office has to have visibility across. Yeah. So I like us managing the centralized view of it, but the business owners and the technicians should be responsible for either updating it directly or for alerting the privacy office when it needs to be updated. Now, here is where I'll give my actual current experience. I'm also over the third-party risk management program. So that, and not just the privacy aspects, the whole thing. So that actually does help me gain a little bit more visibility into when we're bringing in new applications and new systems. But if I wasn't doing that, then you would need to also coordinate with your third-party risk management program and make sure you have visibility to new systems, new applications, new vendors, new locations, new parts of the business, picking up on current vendors, different things like that to make sure you have it. So I do like the decentralized, but flowing through a central dam.
So basically a sort of approval process.
Yeah. Well, just so you have the knowledge, you're the one that has to produce the ROPAs and give them to the regulators. I dare you to get an inquiry from a regulator or from a client asking for a ROPA, and you just hand it to the business and go, yep, here you go, give this to the client. And you're not looking at it, validating that is correct and has the information on it. So I will say it is that, but it does get complicated. I mean, neither of us are saying this is simple to do. There are so many different ways of doing it. There are so many different tools of doing it with. There's so many different approaches you can take to it. I dare anyone to tell me that they are 100% confident that their data inventory, data mapping is 100% complete. Now, it changes day by day, I know.
Yeah.
But at any point in time, can you say, yes, this is complete and full and accurate?
No, I don't think so. And how deep do you go? Do you stop at the first layer? Do you stop at your direct vendors? Or especially if you have an activity base, do you also go the extra mile and also document your sub-processors, or at least the flows to your sub-processors? And how does all of that work?
You make a difference between your sub-processors and your vendors. There is a definition of or processor, let's say. There's a definition of processor, which, if you're a processor, would be your sub-processor. is outsourcing an activity on behalf of your controllers. Therefore, not all your vendors that support corporate shared services used in that activity are necessarily going to be considered processors. For example, your email system. Do you transfer your client data, your controller data via email? Well, of course you do. We all do, right?
Yes.
Even if you block sensitive data or whatever, you use your email system typically in enacting the services, even if it's only just talking to your controller about, whatever. But that's not outsourcing a service for your controller. That's a corporate shared service. So is that a sub-processor? Is that just a vendor? And clients, your controllers, also have very specific views. Here in the US, when we say you have to, the business, the controller, whatever here in the US has to have visibility. It doesn't say to the sub-processors. It says to the vendors or the suppliers, which is different than the definition of sub-processors under the GDPR. And some clients, some controllers only want to know, no, seriously, who are you actually subcontracting the services to? They don't mean your corporate shared services. They mean the companies that are doing part of the services.
But I would mean also the corporate shared services, because that is probably where one of the biggest risks could appear, especially if the email
Absolutely.
if there is an attachment in an email with all the contact details of my company, then that might be a bigger risk than if data is somewhere on an encrypted file share.
Absolutely. Totally agree with you on that one. So it's interesting how you do it, but it's a constant process. If you're a simple company with only one business activity, maybe it's not as complex as others could be, but you don't even have to just document the ones of your services that you offer publicly. You also have to document your internal activities if you're subject to the GDPR or to the U.S. laws that require it, or to LGPD or through PIPL. You have to document your internal services for what you do with your employees. Now, to be honest, most of the laws here in the U.S. exempt employees or the employment activities. But how well do you know how your program is being run and managed and data protected if you don't actually know where your data that you have, including on your employees, is going?
Yeah, no, I fully agree. But now that you mentioned the whole alphabet of data protection law, do you keep one central register, or do you keep separate registers for every single jurisdiction? Or again, do you make some sort of hybrid?
It's a hybrid because some things are shared and some things are not. So, for example, if you have a central privacy office or a central TPRM office or a central security office, a central contract office, you're going to have one process no matter where you are in the world. So if you're all over the world, but everything still comes through a central office, then you're going to have one activity and it's going to be one process. However, typically when it comes to HR, there are very specific requirements for payroll and HR on a country by country, maybe a region by region level that you need to document because you're going to have different vendors. You're going to have different processes. Now, if you can document one whole payroll and then list out, here's my payroll vendors, and list all of them by the country. So you have your corporation and these subsidiaries manage these vendors. Your process can be the same. And then you document which vendors for which location. So you could have one register, but if a regulator comes and asks you for your HR payroll, you're then going to have to separate the one out for that regulator and just give them that information. So I would say if your processes are distinct across jurisdictions, break them up by those jurisdictions. And your internal processes, like we already talked about, HR is probably going to be broken by jurisdiction. If you have a central privacy, security, TPRM, legal, you're probably just going to have one. But if your services are by regions or by continents, for example, if you have a North America versus a South America versus an Asia, then you might very well break up your processes by those regions as opposed to by a particular regulator or whatever, especially if the vendors and the processing activities are the same. And in that case, even if you have a regulator in China that wants to look at it and your process documents, let's say we did Asia Pacific. So it's going to document Australia. It's going to document New Zealand. It's going to document the Philippines. You might still give that to your Chinese regulator, and because it just indicates which country it goes to. But that you need to take into account, and you might not realize how much you need to take it into account unless you get a regulator inquiry. But I typically say break it along the natural lines of how it actually functions in your company.
Yeah. No, I think that makes sense. And I would hope for most companies that helps to get in a streamlined version of their register as possible.
Yes.
Also to avoid double work, because it is already something that a lot of people don't really like to do. So then also making it double work in keeping multiple registers obviously isn't fun. So also try if you use some sort of software to make sure that your software supports your business model when you set it up.
Absolutely. And then there's the interactions with the clients in the contract where they want you to list the vendors or the sub-processors or both of them or anything to provide them a list. And of course, then they want 30 or 60 days in advance notice to approve different ones. That is very difficult for companies to manage. Let's just be honest. That is very difficult for companies to manage. However,
on both sides, by the way.
On both sides, it really is. I love the idea of setting up a trust site where you list everyone and then you subscribe your clients to that site. That way, whenever you change the site, they get the notice. It's automated. Having something like that.
I always disagree to that. I always strike that from contracts because as a data controller, I don't like that.
You don't like what? Getting the automated notice?
Oh, I'm fine with the automated notice. I dislike the fact that I have to go to some website, provide details. I want the contact details in the contract, and it's the responsibility.
Not the same thing.
Okay.
I'm saying a trust site, not that you tell your clients, or your vendors or clients, whichever, that they have to go look at, but one that you keep a track of them. They can go look at it if they want to, but it's an automated, like an RSS. It's an automated feed that will alert them when something changes, not that they're required to go look periodically to see if there's been a change. No, I strike that from contracts too, because that's stupid. But I will also say that the part that gets me is when you have some sort, and this has happened in multiple companies I've been in, they have something where maybe they have an app or a process where this could go to thousands and thousands of people that could be contractors. And they want a list of those. And my constant pushback is no. If I think of Fiverr, there's a good example. Fiverr, you go there, you pay $5, you get a product done. There are thousands, if not hundreds of thousands of contractors on there. Mm-hmm. If Fiverr had to list all their contractors to a client, no. There's no way they could do that on any reasonable basis whatsoever. However, the key point is the controller, the client, will know who the subcontractor is at the time of the engagement of that particular job. But when something changes every day, every hour, even if it changes weekly or monthly, that is ridiculous to expect a processor to give you a list of hundreds and thousands of potential sub-processors. But when it's not meaningful. And in that case, you just have to understand that when you do a job, you will know who the subcontractor is at the time. And companies have to be willing to accept that. Could you imagine getting a list of hundreds of thousands of contractors signed up with Fiverr?
Oh, also there, I would refuse it.
Yeah.
Because I only want to see those companies that are relevant for my contract. If I get an overview from, say, a company like Workday, they have a dozen different products, and then the standard annex includes all of the products with all of the sub-processors in all of the different locations. I would just tell them, hey, clean up this list and only list everything that is relevant for my situation right now. Or maybe for likely products that I would subscribe to in the future so that we don't need to renegotiate the CPA at that time. I'm not going to accept every single thing.
They need to break it up by their processes. Exactly.
And I also don't want a signed version of the data processing agreement that includes...
We've covered this before.
No, but all the various locations from around the world. So if your company is based in the United States, then this is your hosting location. If you're based in China, then this is your hosting location. No, I'm based in the Netherlands, so I only am interested in what my hosting locations are for the Netherlands.
I'm not
Yes.
interested in solving a mystery. Exactly.
I'm also not interested in seeing EU because I cannot document EU in my processing activities register. I need a country.
Yeah, you need to know, is it in Germany? Is it in Italy?
Yeah.
Yeah, where
or is it maybe
exactly
still in
is
the
it?
UK, but haven't you realized that the UK is no longer part of the EU?
Right, exactly.
Because that's also something that I've seen in the past already.
Well, I think part of it is because the abbreviation for Europe is EU, as same as European Union is EU. And so some people sometimes get those mixed up as well. UK is part of Europe, but that doesn't mean they're part of the European Union.
Exactly.
So tips and tricks, that complications that we run into. So what is a shortcut that you have found? Maybe not a shortcut, a trick, a hack that you have found that makes it a little easier to do your data inventory, data mapping, or to maintain it?
Well, I think the best recommendation that I have is to focus on the software. And then you take your contracts and especially the annexes to your data processing agreements and your standard contractual clauses, because they contain a lot of vital information. And while we're at it, when you are doing the templates for your data processing agreement, also make sure that you have all the vital information for your processing activities register documented in there in a way that it's easy for you to process into your register. So that you can always cross-reference your contract management with your register and at least have that part aligned. Then you still would need to go to the business for interviews, but that may be time consuming and you may need to realize that that is never going to be the priority for the business.
Right.
So then this is a fairly, well, I won't say quick fix, but it's a fairly easy fix to at least get a lot of information in that register, in that inventory, so that with some level of certainty, you can say, hey, this is what we do and this is where the data is going.
And if you find a new one that you didn't know about, sometimes that might mean you have to update your privacy notice.
Yes.
So keep that in mind too.
That's the other thing I also keep telling my students. When you draft your notice, never start drafting your notice. Always start with your data inventory, your register, because you draft your notice on that basis, because then you have all the information about what data are we processing, about whom, where is it going to, where is it coming from, how long do we retain it, what is the legal basis, because then you have everything already in that register.
Right. Absolutely. And if you do the systems based, just know that your systems aren't always going to be up to date unless the systems integrate with other systems that are typically used in a business process. The systems people might not be aware of all the little one-off systems and applications that you have as well. For example, me using TrustArc, that doesn't connect to anything else in our system. So I had to make sure our systems inventory knew it, because there was no way they were going to find that. It doesn't connect to anything else. It's the system.
It's not part of your SSO?
Huh?
It's not part of your single sign-on?
No.
Okay. Because that would also be the giveaway. If you're looking for, hey, what software do we have? Use your single sign-on.
Build it into your single sign-on, and then you do have visibility to your system scanning, which does help, which frankly, I think I probably need to go do. Oops.
Well, that's also why as a privacy lawyer, you need to be friends with IT, because then you can make these kind of arrangements and agree with IT. Hey, there is nothing going onto our network, nothing software wise that is not connected to our single sign-on.
Exactly. And single sign-on does help you with a lot of other things as well. So that's a good tip that you can pick up from here as well. Everywhere that you can do the single sign-on, it does help for more than just sign-on efficiency.
Security, visibility.
It does. So I probably do need to get mine added to that.
So even Kay learned a lesson today.
Even Kay learned a lesson today, which, I usually learn lessons from Paul. So I'll just take that as par for the course. So in conclusion, Paul and and we would love, I know we always say we would love your conversation, but we really would. This is learning from each other. It's not a glamorous part of the job. There is no easy button. Do not believe any vendor that says we're going to make this easy for you. There's an easy button. They can make it easier. They can put in some efficiencies. They can help you with documentation. They can help you with discovery, different things like that. They can give you visibility, but there's no easy button. Data inventory is not something that you do easily. And then, of course, every professional has their own opinion as to what works best for them. So it could be that one tool that works really good for other people does not work really good for other people. Because just the way your mind works, you organize things, the way your privacy program needs to be presented, the metrics or the KPIs that you need to
the
present.
visuals that you need, or
Yeah.
how you read your visuals. Yes, I fully agree.
Exactly how you understand it, and know that the people on your team may be the same. They may think totally different from you. So you need to make sure that you find something that works, not just for you, but works for your team, works for your company, and work with a company or a process that you can work with. I will say that customer service is huge. If you have a problem with whatever tool you're using, the ability to call that company, whatever company, and say, hey, this doesn't work. Can I do something else? Can you change this? Can you do that? How do I tweak this? And have someone that really will work with you, because sometimes it's a small little thing that might be a blocker, that you simply can't do this. And if you can't do that, by God, you're going to go use another system. And that other system may be minus 20 of the things that you like to use, but they have that one thing that's a pain point right there. So just know that jumping from system to system and company to company,
Also painful.
there's no easy button.
Nope, I fully agree.
They're all painful. They're all going to take a lot of work. And the other thing is just to know that the reason why a lot of software fails for people is not because the software fails. It's because the people don't learn the software. If you're not in there, you're not working in the tool, then somehow you have in your head, this is a magical button. I'm going to install this software and my problem is solved. No, there's implementation, there's learning, there's use, there's upgrades, there's customization, there's all kinds of things. Although building in-house or customizing an off-the-shelf, I usually also don't recommend. Because if you customize the off-the-shelf, any upgrades they do, you're not going to benefit from. You try to stick with off-the-shelf as much as you can. I don't like on-prem software. My security people might shoot me, but I do believe we hire cloud providers for their expertise, and they can generally put much better protections over it than I can put as an on-prem software. What other tips do we have for working with data inventory and data mapping?
I think we covered it quite well.
Your
And
pain.
Yes, for sure. And on that painful
It's not fun, but it's demental.
note, Kay, given that you did the intro, you're also bringing us home today.
Ooh, and I don't have anything in front of me. So let's see if I can do this. So if you like us, please subscribe. We're available in all of your podcast channels that you can find. Give us comments, give us ratings. We like it. He's making faces at me and I'm going to crack up and I'm going to block him. You can find us on LinkedIn under Serious Privacy. You can find us on most social media channels under Serious Privacy, Podcast Privacy. You can find Paul as EuroPaulB. You can find me as Heart of Privacy. And join the conversation. Let us know what you're thinking.
Until next week, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMD research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, Create a cookie banner or start an assessment? Quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.